Welcome. If you're deep in prep for the California bar exam, you know torts can feel like an absolute minefield. That's why today, we're not just studying, we're building an attack plan for one of the most tested, most critical concepts out there, the duty of care. Seriously, if you get this down, you're not just memorizing a rule, you're building the bedrock that's going to carry you through any torts essay they throw at you. So let's get into it.
Okay, let's kick things off with a classic bar exam hypothetical. You've got a business, Megamart, you have a customer, and bam! A criminal act. It's exactly the kind of messy fact pattern designed to make your head spin. You look at this and think, where do I even begin? But don't worry, by the end of this explainer, you'll have a crystal clear framework to absolutely crush a problem just like this.
So, here's our roadmap for today. We're going to start with the basics, the 4 elements of negligence. Then, we'll dive deep into the legendary Palsgraf case to figure out who you owe a duty to. From there, we'll tackle the tricky no duty to rescue rule, and more importantly, all its exceptions. And then, for the grand finale, we'll put it all together and solve that Megamart problem once and for all.
Look, any high-scoring legal analysis starts with a rock-solid framework. And when it comes to negligence, that means you have to master 4 key elements. This isn't just, a helpful tip. It's absolutely essential if you want to write a torts essay that gets you the big points.
And here they are: duty, breach, causation, and damages. Think of these as the 4 legs of a table. If one is missing, the whole thing collapses. On the bar exam, you've got to analyze each and every one. But for today, we are zeroing in on that first and arguably most important one, duty. So what in the world is a duty? Well, think of it as the gateway question. It's a question of law that asks, did the defendant owe the plaintiff any legal obligation to be careful in the first place? Because if the answer is no, the case is over. It literally doesn't matter how careless the defendant was. No duty means no case. It's that simple, and that's why it's so critical to get right.
And that question brings us right to the heart of the matter. We're about to talk about one of the most famous cases in all of American law, Palsgraf v. the Long Island Railroad. This case is a legend because it answers that fundamental question: to whom exactly do you owe a duty?
I mean, really think about that for a second. If you act carelessly, are you responsible for every single person who gets hurt, no matter how wild or unpredictable the chain of events is? Or is there some kind of limit? That's the huge question the court had to wrestle with in Palsgraf. And this right here, this single sentence from Judge Cardozo is everything. It's the answer that shaped American tort law forever. The risk reasonably to be perceived defines the duty to be obeyed. In other words, it all comes down to foreseeability. Let's see how we got there. The facts of this case are so bizarre, you honestly couldn't make them up. So you've got these railroad workers trying to help a guy get on a moving train. They give him a push, he drops the package he's holding. Turns out, it's full of fireworks. It explodes, the shockwave travels all the way down the platform, knocks over a huge set of scales, and those scales fall on and injure Mrs. Palsgraf. It's a completely unbelievable chain reaction.
So what did the court decide? They said the railroad owed no duty to Mrs. Palsgraf. And the reason why is everything. She wasn't a foreseeable plaintiff. Cardozo argued that the negligent act was pushing the man. The foreseeable risk from that was maybe injuring the man or his package. No one could have reasonably foreseen that it would cause an explosion that would injure someone standing way down at the other end of the platform. She was, in his famous words, outside the zone of danger.
And this case perfectly sets up the 2 big competing ideas about duty. On one side, you have Cardozo's majority view. Duty is relational. It only extends to people inside that foreseeable zone of danger. On the other side, you have Judge Andrews' dissent. He argued for a duty to the world. If you act carelessly at all, you owe a duty to everyone who gets hurt, and we can just use proximate cause to sort out the wacky results later.
Okay, bar exam alert. Here is the absolute key takeaway. On your essay, you always apply the majority rule, the Cardozo zone of danger test. You state the rule: a duty is owed only to foreseeable plaintiffs, and then you use the facts to argue why your plaintiff was or wasn't in that zone. That is how you get the points.
All right, so we've established the duty to act carefully. Now let's completely flip the script. What about a duty to act at all? This brings us to another fundamental and frankly kind of surprising principle in tort law.
So here's the general rule. There is no duty to rescue. The law does not require you to be a good Samaritan. You can literally be standing there, watch someone in terrible danger, and legally you can do absolutely nothing, even if helping would be easy and totally risk-free for you. This rule is all about protecting individual liberty.
But, and this is a huge but for the bar exam, knowing the general rule is only half the story. The real points are in spotting the exceptions. If you get an essay question about someone failing to do something, what we lawyers call nonfeasance, your entire job is to hunt for an exception that creates a duty.
This slide right here is your cheat sheet. This is gold. Did the defendant start to help and then just stop? That's assumption of duty. Did their own actions, even if they were totally innocent, create the dangerous situation? That's creation of peril. And the one you will see over and over again on the bar, was there a special relationship, like a business and its customer? Ding, ding, ding. If so, a duty to act probably exists.
And here is another pro tip for writing your essay. You want to show the grader that you know the whole picture. So, you start by stating the general rule. Generally, there's no affirmative duty to act or rescue. Then, you use a magic transition word like however, and you dive straight into analyzing every single exception that could possibly apply. That's a top-tier analysis.
All right, it's time to bring it all home. We're going back to that Megamart problem from the beginning. But this time, we are fully armed with the analytical framework we need to solve it. Let's put these rules into practice and see what a perfect answer looks like.
Okay, here we are again, Megamart, the poorly lit parking lot. We know other thefts have happened there before, and then our customer gets attacked. Remember, the question isn't, was Megamart careless? That's a breach question for later. The threshold question is simply this: did Megamart owe any duty at all to protect this customer from this kind of crime?
And here is exactly how you break it down for full credit. 1. State the general rule. Generally, a landowner has no duty to protect people from criminals. 2. Find the exception. However, a special relationship exists between a business like Megamart and its customer. 3. Analyze what that means. This special relationship creates a duty to protect patrons from foreseeable risks, and because we know thefts had happened before, this attack was foreseeable. 4. Conclusion. Yes, Megamart owed a duty of care. Boom. Done.
So there you have it. You've got the rules, you've got the framework, you know how to ace this issue on the exam. You know that legally you can often just walk on by. But it does leave us with a bigger question, doesn't it? Does a law that puts individual liberty above, say, saving someone's life, does that reflect the kind of just society we want to live in? That's something to think about long after you've passed the bar.